Hey guys, George Souris, Empire Legal, back for another blog. Hope 2025 has been a cracker for you all so far. Bigger and better year than last year. Let's get into it. So today I want to talk about pre-contract advice. We review standard REIQ contracts as a part of the conveyancing process. Today I'm going to explain the main things that we look for when we review contracts for clients here at Empire Legal. All right, so section 1, property and contract. What are you buying? A house, a unit, or vacant land? That's going to affect the type of contract that is used. When we check this, we also check that it's the current version of the REIQ contract. This is because if it's an old version, the laws may not be accurate. It's always best to be using the current version of the contracts, and we'd suggest if it's an old version that it be redrawn up on a new one. Next, we check the contract date. The contract date will be the date the last party has signed and each party has agreed on all terms. You will not be bound by the contract until you or we receive a fully executed copy. This means that if you sign and return the contract, you can withdraw your offer at any stage up until the fully signed contract has been dispersed. Of course, providing the sellers haven't already signed. We then take note of the square meterage as noted on the contract for the property you are purchasing. Now, if this is a unit, we recommend that you satisfy yourself with respect to the total area which forms part of the lot you are purchasing. For example, in some body corporates, the car park is included as part of the lot. In others, it's common property or exclusive use, allocated to the lot. The registered plan will indicate the size of the lot you're purchasing and which areas are included as title for the lot. The CMS or Community Management Statement provides all this information. If you can't get a copy of this from the seller or the agent, we can order it for you from the titles office. If you need help with that, just let us know. All right, next step, purchasing entity. We want to bring to your attention the purchasing entity or entities. So traps for young players, not putting the full names, including middle names of all purchasers correctly reflected on the contract. So that's super important, guys. You want to make sure that's all correct because once it's signed up, you cannot change the purchasing entities unless it's like a minor typo. We just have to contact between solicitors. All right, next, purchase price. If this does not correctly reflect the offer you're making, you can cross it out, write your new offer, and initial where the changes are made, or ask the agent to change it on DocuSign. Next step, insurance/risk. Although the seller has a continuing obligation until settlement to take reasonable care of the property, from 5 p.m. on the next business day after the contract is signed, it will be at your risk. So if this is a house, you want to straight away get full replacement value with an insurer. This is super important, guys. And of course, if you're getting a mortgage, that lender will need to be noted as first mortgagee. If it's a unit, standard process is that the building replacement is covered by the insurance of the body corporate. However, each case is different. So we suggest at a minimum, you make sure that all the internals of the lot, for example, carpets, curtains, internal blinds, and public liability is sorted out on your end and you have cover. Okay, next step. Time essential. So time is of the essence of the contract. This means that you must perform all of your obligations under the contract strictly by the due date. For example, you need to be ready, willing, and able to settle on the settlement date. Otherwise, the seller can terminate or affirm the contract. In both cases, the seller would be able to claim damages from you and your deposit is at risk. Next, cooling off. So contracts are subject to a statutory 5-day cooling off period where you can terminate the contract if you change your mind. Unless, of course, you waive your cooling off rights, which is a separate form. If you do terminate under cooling off, there's a 0.25% of the purchase price penalty that gets deducted from the deposit if you terminate in that manner. Guys, next section is deposits. You've got an initial deposit and a balance deposit. So you put in the amounts there. It's all subject to negotiation and the timeframes of when they're paid. For cybersecurity reasons, make sure you telephone the deposit holder and verbally verify the account details before you transfer any money. If you don't pay any deposits on time, you as the buyer will be in breach of the contract and the seller may terminate the contract, your deposit forfeited, and you could even be sued. So that's a not negotiable. We put all this in writing to you guys, this whole pre-contract advice as part of our service here at Empire Legal. We strongly recommend you send the remittance for your payment of the deposit through to the deposit holder ASAP, and also to us once you have made payment. That's important. All right, moving along, next section, finance. The contract is subject to you obtaining a loan from the lender listed on the contract on terms satisfactory to you by 5 p.m. on the due date, providing all 3 sections are filled out. You've got to take reasonable steps to obtain finance, which includes making an application without delay to the bank, And if you don't obtain a loan on satisfactory terms to you, you can elect to terminate the contract, your deposit refunded, and the matter at an end. If this isn't filled out, no finance clause, and you've got to find the money. You can't terminate if you don't have the funds. Okay, next section is building and pest. Similarly, if this section is not filled out, the contract is not subject to building and pest, and if you find any issues, you're not allowed to terminate the contract. You have to buy. Alternatively, if it is filled out, you've got until 5 p.m. on the due date to be satisfied with the reports from a licensed building and pest inspector. And if you're not happy with the reports, you have to act reasonably. You may terminate the contract by giving notice before 5 p.m. on the due date. Your deposit would be refunded to you and the matter at an end. Something like a leaky tap is not acting reasonably, but termite, water damage, major problems would be. Okay, we're nearly there, guys. Next section is smoke alarms. So we strongly recommend before you sign a contract, you check with the agent whether the smoke alarms are compliant with the property. It's now law, so compliant smoke alarms have to be put in the property. If they're not, you as the buyer inherit this risk and you have to sort that out after settlement. There is a section in the contract that if written notice is given before settlement, 0.15% of the purchase price can be adjusted in the buyer's favour in the event that there's not compliant smoke alarms. Only way to find that out though is to go and inspect that with an electrician that's licensed to give you that advice. So easiest way around it is get those certificates beforehand if you can. Don't have to worry about the inspection. All right, next section we check is settlement, guys. So there's a settlement date or a time frame. For example, 30th of June or 30 days from the contract date. You've got to make sure you're ready to settle, otherwise you'll be in breach of contract and you can risk the deal falling over and you being pursued, i.e. sued. In saying that, by default, we now have clause 6.2, which is the settlement extension notice, which allows either party to extend for up to 5 business days, as long as they give notice in writing before the settlement. We've done a whole nother blog on this if you want to know more, but that's a good one. It can buy you some extra time. Bit of a trap. Some agents cross this section out, so you want to make sure that's in there. This is something we check for you as part of the pre-contract advice at Empire Legal. We let you know about rego fees. So there's extra fees, registration fees that are payable to the titles office to transfer the land. Next, we let you know about transfer or stamp duty. So how much that's going to cost you, because these are all extra fees that government charges that you can't get out of that you have to pay. So you've got to factor that in. Usually your broker or your banker will tell you about this, but we let you know as well. Next section we check, included chattels, excluded fixtures. So chattels are if you were to turn the house upside down and shake it, anything that fall out. So we check that for you and advise what's there. If it's blank, all the chattels must leave the property and all the fixtures must stay. Next section, pool safety. So we check there's a compliant pool safety certificate, and if not, let you know the consequences there. Then there's a special conditions box. This one can have all different things in it, from subject to sale, due diligence, all sorts of stuff, sunset clauses. So if there's anything in there, we pick this apart and give you that tailored legal advice so that you know what you're signing. Next section is tenants. So if there's tenants in the property or if it's going to be subject to vacant possession, keeping in mind the new laws with the rent increases, that can only happen every 12 months now. So we give you all the legal information you need to know about these two sections. Then easements or encumbrances. So matters affecting the property. This is where statutory easements are put in, for example, sewer mains, stormwater mains, manhole covers, etc. If you've got any intended future use of the property to, say, put a pool in or develop, this section is super important, guys. You want to make sure you're able to do what you want to do with that property. So we check that out, and if there's anything funny in there or on the title search, we'll let you know. Next section is buyer beware for searches. So in Queensland as it stands, it's buyer beware. We have to do your own due diligence. If you have any particular concerns about the property, this is where you want to let us know so we can give you tailored special conditions or legal advice. A really important one here, guys, is council building approvals or final inspection certificates. So in Queensland, there's no obligation to provide them by the seller. So if we do a search and we find that there maybe isn't a final approval or building approval, can't terminate the contract, unfortunately. There's no standard terms that allow that. So if you're concerned about this, we can do these searches up front. Signing the document. So to sign the contract, 99 out of 100 now are signed electronically via DocuSign. However, you can also wet ink sign. We give you the instructions on how that process works. So we're going to wrap it up there, guys. Standard REIQ contract, pre-contract advice. If you're buying, it's not negotiable, mission critical. This is a service that's part of our fixed fee conveyancing package. All of our pricing's on the website, super transparent. We've got over 2,500 five-star reviews, guys. Pick a conveyancing team that you can trust. This is seriously important. You need to pick the right people to look after you. This is all we do. We want to help you. If you're a real estate agent, a mortgage broker, or a banker, and you have clients that need help, we want to help these clients. Get in touch with us today. I hope that helps. If you've got any questions, send us an email, george@empirelegal.com.au. Agents, you can also pass this on, or brokers, bankers, to your clients as a nice little bundle of what to look out for at the pre-contract advice stage of buying a property in Queensland. Thanks, guys. Ladies and gentlemen, please keep in mind that all advice is general in nature and does not constitute legal advice. This is authorised by George Souris, Empire Legal, Gold Coast, Queensland, Australia.